Okay, now we're going to start first off with talking about trademarks. Trademarks are a lot of fun and a super cool area of law that I've really gotten into, and it's one of my favorite things to do with clients. Why I love trademarks is because it gives you the opportunity to lock in either a word, a series of words, or a logo and words together and say to the world, like, yo, check me out, like a little bit of that going, and like, look at what I've just created. And now nobody else is allowed to use it. It's my contribution. It's the one thing that I've done. Nothing jazzes me up more than that. Maybe stepping on an airplane and going to a random country gets me a little bit more excited, but they have to be on the same level. And when you work with entrepreneurs and you work with business owners, getting to the point of setting up a trademark is like, it's like, get the champy out, let's do this, we're doing it right. So first I want to explain the concept behind trademarks, just so you understand. So this is the deal. There's two things going on. One is that the government says, and either in the United States or in Canada or in Europe, anywhere around the world, the government says like, okay, look, there are all these super awesome people who are doing cool things in the world. We want them to be able to protect their ideas. Wicked? Yes. Love it. All for it. Let's do everything we can to help them protect their ideas as much as possible. The second reason why we have trademarks, and this is like, if you think about it, it's pretty cool. Like they knew what they were doing. The second reason why we have trademarks is that we do not want to mislead the public in believing that something, a word or a logo or a business may actually belong to someone else. So all of it is under this idea of protection and of exclusive use. And we want to make sure that the public at large is not misled by someone creating something or copying something and then going off and stealing it. So trademarks equal protecting your awesome idea. How is it protected? What a trademark enables you to do is two super important things. The first is you get to be the only one who's allowed to use it in a particular way, and we're going to talk about the specifics of trademark registration and how you're going to use the mark and what it covers and what it doesn't cover. But the one thing is it says, hey, I'm the only one allowed to use it, and this is big, getting ready for number two. What a trademark also does is say to anybody else, nah, you're not allowed, not you. You didn't come up with this, you don't have the rights, this is my idea, this is my logo or word or series of words, and I'm gonna do everything that I can to enforce it. So now very quickly, you've got an awesome logo or word or series of words. The question is, what can you trademark and what can you not trademark? And I'm so happy you asked that question because I've actually got the answer and I think you're gonna love it. So a couple of things that you're not allowed to trademark. You're not allowed to trademark a name because obviously someone else may have that name and you're not allowed to have the exclusive right to using that name because it is your name. You're not allowed to trademark words in other languages because I don't know why, so I'm just gonna say. You're also not allowed to trademark words in other languages. You're not allowed to trademark places of origin or locations around the world because that's a place in the world, and how can you exclusively say that you're allowed to do that? Also, you're not allowed to register something that's misleading. So if you're saying that you're doing something in your trademark but you don't actually do it, you would not be allowed. So an example of something that you would not be able to trademark as well is something that's misleading to the public. So in the name of the trademark or in the mark itself, you're saying that you offer certain services, but you don't actually offer those services. That would not be permissible. Outside of that, and again, the caveat for all of this is just checking the different registries and doing the appropriate searches beforehand. Outside of that, you should be super kosher for what you're trying to trademark. Also, you're not allowed to trademark descriptive marks. So like an adjective related to something or related to the services that you're offering. Another example of something that you would not be allowed to register is a descriptive mark. So for example, if you're a yogi and you're trying to register relaxing shavasana as your mark, that would not be permissible. Outside of this list that we've provided to you, game on. Do what you want. You got it, and I believe in you. From beginning to end, there's a particular process of how trademarks work. The first thing that you want to know is that you're going to have to conduct a search to see if the mark is available, right? Because like coming back, big picture, we want to protect people's ideas. So you have to make sure, like, okay, first things first, no one is using this particular trademark in a very similar way that I want to do it. And when you do a search, you're going to go through, and either in Canada or in Australia or in the United States, there will be a list. You're going to put in a term, and there will be a whole list that comes up of things that are similar or not similar. And ideally, you want to, in the search, you want a result that comes back with like nothing even close. Like I've thought of, when I put in conscious counsel, there was nothing similar to conscious counsel, and I knew like, okay, I've got a really, really, really good chance of getting this, being able to register this trademark. And it's a whole long process. It took about 2 years in total. But the first thing you want to do is like, okay, make sure that no one else is doing it. So the first part is doing the search. Now, two things are going to happen in the search. One of the things that's going to happen is that it's going to come back scot clean, like it did with Conscious Counsel for me, or with Radically Aligned and Deidre, who you're going to hear from in a bit. When that happens, green light, awesome registration. It also helps at that point, go on Google and maybe do like a company search to see in your state or in your province if anyone has registered a company with that same name. If you're good on those two fronts, there's nothing on Google, there's nothing in the trademark registry, there's nothing in that state or province in terms of a registered company, then you've got an excellent chance to have the registration approved, pending the specifics. But let's just say asserting the name. At that point, you're in great shape to have your name approved. What will happen sometimes is you're going to put in a particular mark, and there may be some issues around it in the sense that, it's really similar to something else that is out there. What are my chances? Now, the specifics of that depend on, okay, what is that mark? How similar are they? How are you planning to use that mark? And how is that mark currently being used? So there could be a business there could be two businesses that both have a trademark to the same name, but they use it in such completely different fields that the public would have no idea to confuse them. They'd be like, you never come across these two things the same way, no worries. In that case, it's still advisable to move forward with your trademark. It can be, circumstance pending. Okay, so we've done the search. Either nothing's come up in your money, or something has come up, and then you have to think twice about the registration. At that point, it would help working with a lawyer to decide, or you can just go for it and hope for the best and see what happens, or you can decide to maybe pivot and go with a different mark or a different name. The next thing that you're going to do during registration is you're going to describe how you plan on using this mark. So, am I going to be selling goods? Am I going to be selling services? If I'm selling goods, what sort of goods am I selling? Am I selling clothing? Am I selling travel services? Am I selling dog products? If it's a service, am I selling coaching? Am I selling legal services? Am I selling photography services? And the whole idea is that you have this mark. So now this is my big piece of pie. This mark is my mark I'm going with. You get specific and you carve out your particular niche of how you want to use this mark and how you intend to use it in the future. What's important to know here is that there's a fine line of not wanting to try to secure too much and not wanting to secure too little. So oftentimes I've had clients who've approached me and they're like, I want it for everything. Give me everything. I'm so excited and so happy about what I'm making. I want to register my mark for dog bibs and spaceships and yoga mats and weights and all the things. And I'm like, well, are you actually using it? They're like, no, but I don't want anyone else to do that. So again, what we're doing is we're going to be very, very specific about how we intend to use it, what we're using it for, either for goods or services, and we don't want to be too overreaching. Because if you're greedy, it never pays off. Remember, if you're greedy, it never pays off. What you're going to do is think about like, okay, realistically, I'm going to do tank top sweatshirts and maybe I'm going to do toques, or as Americans call beanies. And by not over leveraging how much you want to use it for, you're sort of showing the registry like, hey, what's up? I'm a real person. I'm not trying to carve out too much of this piece of cake that I know doesn't really belong to me, and I'm just going to put in for the services that I'm actually intend on using instead of going for everything. So now we've done a search. We know that our name is good. We've described exactly what it is, what our intentions to use this mark is for. And the next thing we want to do is talk about, okay, have we used it? Have we already used it? And how long have we used it for? So that is why I always recommend to clients, the first moment you used this particular mark on an invoice or someone paid you for services involving this mark, keep that receipt, you frame it, you go to the frame shop, you get so excited about it, and that is the first time you used it for commercial purposes. That is going to be the first date of use. That's the best proof for date of first use. Alternatively, it's possible that you want to reserve something that has never been used before, ever. So if that's the case, you're going to mark it as a proposed use. And at that point, you have a certain amount of time to make sure that you actually use it in that way. Now, I want to tell you a story about proposed use versus intended use. And one of my first files in working with trademarking, I was representing a client. They came to me after they had done the registration with someone else. And there was an issue about who had used a particular trademark first. At that point, my client did not have an invoice from the first time they used it, which is why, like, reminder, whatever you're doing with business, you want to go and you want to find the first date that you use something in commerce and you keep that invoice and you love it. And what happened was their trademark was actually challenged, even though they had gone through the entire process. The trademark was challenged because in filling it out, they had added things for proposed use, which means like, oh, at the time they're like, yeah, maybe we will use this for picnic blankets and for picnic baskets and all these picnic related things. Obviously it wasn't picnic things, but that's the example I'm giving you because I can't tell you what happened. And the other side said like, wait, we see that you have better priority. We understand that you have an invoice from this particular date, which is before ours, but actually your registration is invalid because you said you were going to do it for all these things and you didn't actually do it. If you say that there's a proposed use and you don't actually use it, sometimes you just lose the ability to have the trademark apply for that. But what it does is it provided the other side leverage in our negotiations, where they said, things are not actually as awesome as you say they are. And as a result, our case is a little bit stronger than you think. So that gives us leverage in our negotiations of what we're doing together. All of that is a story to say, when it comes to proposed use, just make sure that whatever you're putting down is something you're actually going to use it for. And when you talk about date of first use, make sure that you have a receipt for that first time that you use that mark in business. When we talk about registering a trademark, we want to talk about the rights that you have and who has better rights, because it is possible that you have a mark or a word or a logo that you've been using. Someone else like secretly is like, whoa, that's super cool. I want to go register a trademark for that right now. Normally, the deciding factor between that will be who was using it first, how were they using it, and can they prove that they were using it first. And that's why this important information of having an invoice that's dated, that someone paid you in connection with services for that mark, that puts you in prime position. And that same client where the issue came up of proposed use, the entire issue was who could prove that they were using it first with the better form of proof. And I think we had a Facebook photo that was time-stamped, that like you could see the trademark sort of in the background, but not really. So the issue with that client came down to date of first use. So the recommendation very, very quickly and very importantly is get an invoice. Put that trademark on your invoice and the better priority will be who used it first. In terms of being proactive, it's super important that you take the initiative to register your mark. That's why like pay me now, pay me later. It's the one story I continually tell throughout this entire course, the importance of being proactive, taking the steps. It'll cost you $1,500 up front, or it could be $4,000 to defend it later on. Also, if we're talking about perspective, what you're building here is your brand. Your brand is your life. It's your dream. Every time you're on the bus, every time you're riding a bike, every time you're sipping coffee, you're like, this is my contribution. It's going to be amazing. I love it. Take the effort to be responsible, register it accordingly, and let both the government and the world know like, hey, this is mine, this is my idea, this is how I intend to use it, this is how and now everyone's on notice. Like everyone knows. When you see that and it's awesome, you love it. In terms of where we are, so we've done the search, we've said how we're going to use it, we've either spoken about proposed use or the first time that we used it, and then you just submit, and then you just love it, and you wait for 2 years because governments can be really backed up in the services that they offered, and trademarking can take a long time. But this is a really important point for you to know. The rights that you have in your mark start at the moment of registration. So it's not, getting the certificate is a super cherry on top, and there's a whole long process of things in between that you don't need to think about or worry about at all. You need to register and then just enjoy the benefits from that point. In terms of being proactive, let's say someone else has beat you to it, then what happens is you can challenge that trademark registration. They may have registered, but if you can show that you have better priority and that you use the mark first, you can challenge it. That will be expensive. There's no, I'm trying to help you do law in a budget and in a style that works for you, but if someone else beats you to it, it will be expensive to fix it, but you can fix it by showing that you were the one who used it first and this other person has copied your idea. Again, assuming that it was done in the same way, in the same field, and basically in a way that would mislead the public. In terms of the search, easy peasy, you got it. I know that you know how to use Google. For Canada, you'd put in Canadian Intellectual Property Office, and in the United States, you'd put in USPTO, United States Patent and Trademark Office. There's a search engine built into it. The Canadian one is a bit friendlier than the one in the United States, but you just put in your mark and you see what else is out there. Now, in terms of deciding when to trademark, there are a couple of factors at play, and I'm going to share with you the story of Conscious Counsel, and we're also going to hear from Deidre at Radically Aligned, and she's going to share her story of when and why she decided to trademark. With Conscious Counsel, I didn't trademark right away. I had thought of the name. It's actually a great story, and I'm so happy to share the story with you now. I went to Victoria, British Columbia when I was working, just started out as a lawyer. I went to visit one of my friends who works at the Institute of Holistic Nutrition. And we were chatting about all the things in life and being a lawyer. And I was like, yeah, and I love working in the consciousness realm and working with heart-leading entrepreneurs and all these people who are super passionate about building communities and doing amazing things. And I'm pretty selective about who I work with. I don't want to work with particular individuals who I don't connect with or who don't align with my vision. And she's like, oh, so basically like you're offering conscious counsel. And I was like, yes, that is what I'm doing. I'm offering conscious counsel. And that was the seed of when all of it started. And knowing what I know about trademarking and business names, then I did a bit of searching and I saw that there was no trademark for Conscious Counsel. I was actually a little bit surprised. I'm like, whoa, this is so awesome. How is someone else not using it? But before I did that, I registered as a sole proprietor under the name Conscious Counsel. So as important as it is to have an invoice from the first date, also registering your business as an LLC, as a sole prop, as a partnership, and using that particular mark that you plan to, that is very, very, very good evidence and like super, super helpful if you're trying to assert that you were using something first. What could be better than registering a business name or a sole prop or a company with the mark that you intend to use? So at first I registered as a sole prop and I got it. Like I'm chilling. I know Conscious Counsel is out there. And then I hadn't registered for trademark, but now we're talking about growth. We're talking about scaling. Pretty early on in my business, after I launched my Instagram, I was getting these emails from all over the world, from Italy, from South Africa, from all these different states in the US. And people were saying like, whoa, this is awesome what you're doing, being a lawyer and a real person. I want to do it too. And at that point, I was toying with the idea of creating a law firm in a box, which is one of the 3 million ideas that I've had in my life. But the idea being that I would help people set up their own conscious counsel and like, hey, what is your niche? What are you passionate about? How do you want to send your message? And go visit them for 2 weeks, 2 or 3 weeks, help them set up their law firm and then leave and basically give them all the support and the documents and all the things. Never ended up happening. But it was very clear to me that if I wanted to use Conscious Counsel in that way and have it be a vehicle that I could let people use and say like, it's an awesome name. We've got a super sweet logo. Clearly you can build your business around it. I needed to protect that myself first. And before I can give something away or let someone use something else, I need to clearly assert that it's mine. And that was the moment that I decided to trademark Conscious Counsel. So once the business name was established, I could prevent someone else or I could challenge someone else from registering, but I wasn't sure exactly how I was going to use it, so I didn't know. That being said, the moment that the opportunity to go into other places occurred to me or the opportunity presented itself, that was when I really thought to myself, like, okay, I need a trademark so that it is extremely clear what rights I have to using this particular term and to using this particular logo. And as such, because I so clearly own it, I can go to someone else and be like, yo, check it out. Like, this is what I've got going is pretty sweet. I've got my copyright. I've got my trademark, I've got my certificate. You can now pay me X number of dollars a month in order to use the term Conscious Counsel, and you will have the same trademark protection that I have. And that protection means that no one else is allowed to use it. And thankfully with Conscious Counsel, nothing has come up where someone else has tried to do that. But I know that if someone comes up with a similar mark in a similar way, I can write them a friendly letter. I'm a friendly lawyer. I'm not an unfriendly person. So I can write them a friendly letter and be like, love you, love what you're doing. I'm so stoked you're conscious like me. This is my trademark. These are the ways that I'm using it. This is how long I've been using it for. Let's find a way that this can work for both of us. And that could either mean them choosing a new name, or that means that they could pay me for a licensing agreement in order to continue using that name. So there's no right or wrong answer about when you want to register your trademark. We're going to hear from Deidre, and her story is a little bit different because she was just like, she had an aha eureka moment. She was sitting under a tree and she was like, this is my name. I need to trademark it and I'm going to build my business around that name. When you're so committed and you totally know that it's the right thing, boom, you go on and do it. For me with Conscious Counsel, I was starting up, I was supporting myself. I don't have any investors, so I didn't have the capital at the beginning of my business to really say like, okay, I need to trademark it right away. I asserted the rights and the property to it, super, super important thing to do. So I registered the sole prop. Now the government knows that from a particular date, I've been using this name as my business. And then as things grew and as I continued going and there was an opportunity to possibly license it out, I registered my trademark. So a quick summary about trademarking. Again, this is a really, really exciting phase of your business because you're asserting your brand, your image, your word, your series of words, and you're saying to the world, what's up? This is mine. No one else gets to use it. I can enforce these rights however I want to. I can also let somebody else use it because I've set the foundation up properly. And in letting them use it, I can make some pretty sweet cash from it also. The questions are, what can you trademark? What can you not? You're not allowed to trademark things that are specific to a place or a name because, like, remember, you're restricting someone else from using something. So you can't use a term that would restrict someone's freedom of what they would be able to use otherwise. So like, I can't trademark Corey Sterling as a name because there could be another Corey Sterling out there. And who am I to say that that person is not allowed to use their name in everything that they do? So we know that we're trademarking either a logo, a word, a series of words. We know what is trademarkable and what is not trademarkable. We also search to make sure, we search the relevant databases, we search Google, we do company searches to make sure that that's available. I'm like, hey, I'm not stepping on anyone's toes. I acknowledge this process. I respect other people and their ideas, and I'm gonna let them, if they've already done it, I'm gonna let them have it. Conversely, if I'm first to market and I've come up with this awesome trademark, I'm going to go for it myself. We then outline specifically how we intend to use the trademark. So remember, trademarks in different industries can apply as long as it does not confuse or mislead the public. It is trademarkable, it is registerable. Then we have to go to either the use, so the first time you used it, registering a company name or getting an invoice with the mark on it is really helpful, or the proposed use. And again, just being mindful and careful for proposed use. You don't want to overreach and be greedy and try to capture it to cover everything. And then lastly, it's just registration and then waiting in the process, but remembering that the rights that you have in that trademark begins upon registration. If it so happens that you've come up with a mark first and someone has copied you and they registered their mark before you, it's cool. You can challenge it and it'll be a process. It's not the simplest thing to do to challenge it, but you can, and it'll be a little bit more expensive to do so. But the longer you wait to challenge a mark, the more expensive and the more difficult it will be. So that's everything you'll need to know about trademarks to get started. It's with such great pleasure that I share this information with you, because this is exciting. We're building up and we're doing great things. And I hope you love and enjoy this process and really just have fun with it, because it's about you taking your dreams and your vision to the next level.